Welcome, welcome, my beautiful people, to the final day in November 2022. Today is Wednesday, November 30th, 2022. Is it okay if I videotape? Thank you so much. Thank you. We're on page 358, chapter number 19, breach of contracts and remedies. What can be done when a contract is broken? What can be done? That's the question. I have in my margin. What is a remedy? What is a breach? The question of remedies does not become important until it is first determined that a contract has been violated or breached. Okay. What is a breach? A breach is 19-1A, page 358. A breach is the failure to act or perform in the manner called for by the contract. Oh, they don't do what they're supposed to do with the contract? When the contract calls for performance such as painting an owner's home, the failure to paint or to paint properly is a breach of contract. If the contract calls for a creditor's forbearance, the creditor's action bringing a lawsuit is a breach of the contract. Okay, what's an anticipatory breach? Who made an anticipatory breach in our studies? What cast? Mr. Jose? Mr. Nicholas? Mr. Jesus? What's your shirt say?
Friends.
And that's the answer. Friends. Yes, Friends. The Friends cast, right? Absolutely. Okay. So, and also they made a what? Anticipatory what? Repudiation? Right? August 12th, right? 1996? Where was I? 19-1B. Anticipatory breach. When the contract calls for performance, a party may make it clear before the time for performance arrives the contract will not be performed. This is referred to as an anticipatory breach. Okay. Who blinked the first time in the Friends case? NBC. And they gave the Friends cast a what? Beginning with a W from the last chapter.
A waiver.
A waiver. Very, very good. What about substitution? What about novation? What about that? What about releases? Oh, that's all in this chapter now? Okay. What is an anticipatory repudiation? When a party expressly declares that performance will not be made when required, this declaration is called an anticipatory repudiation of the contract. What do you need to have an anticipatory repudiation? That's my question in my book. What do you need to have an anticipatory repudiation? What's the answer? To constitute such a repudiation, there must be a clear, absolute, unequivocal refusal to perform the contract according to its terms. Right? That's the answer. For example, Procter & Gamble, P&G sought payment on 4 letters of credit issued by Serbian bank, Investbanka. P&G presented 2 letters by June 8th prior to their expiration dates with the necessary documentation for payment to Bank New York, Investbank's New York agent. A June 11th letter from the bank broadly and unequivocally stated the bank would not pay the letters of credit. 2 additional letters of credit totaling $20,000 issued by Investbanka that expired by June 30th were not thereafter submitted to the New York agent bank by P&G. However, a court found that the bank had anticipatory breached its obligation under those letters of credit by its broad renouncements in the June 11th letter, and judgments were rendered in favor of P&G. Who else had an anticipatory repudiation? It's going to be on your test. Jesus, the answer is your shirt.
Friends.
The Friends cast. We have a Friends cast. For those who are listening, he has a Friends cast sweat jacket on right now. Okay, very good, right? And in fact, what did the Friends group cast want?
More money.
And what else?
A percentage.
And what's Jesus have on?
Percentage of the merchandise.
Yeah. Okay, that we consider merchandise, right? Exactly. Okay, very good. So Curt Flood, reserve clause, Muhammad Ali, that's going to be important. I'll get to that in a minute. What is not an anticipatory repudiation? Somebody read that for me, please, on page 359, top. Nice and loud. Come on, somebody. All right, you're shy. That's okay. A refusal to perform a contract that is made before performance is required unless the other party of the contract does an act or makes a concession that is not required by the contract is an anticipatory repudiation of the contract. So a refusal to perform the contract that is made before performance is required unless the other party of the contract does an act or makes a concession that is not required by the contract, then you have a what? An anticipatory repudiation of the contract. Conjunctive adverb. However, a firmly stated request for additional payment under existing contract without refusal to perform until the additional payment is made is not a repudiation of the contract. Then you have what? Synisys Trucking Company, August 14, 2009, letter to Thistledown Racetrack seeking additional payment for hauling straw and manure from the raceway's horse stalls, stating accept this as notice that we will haul your manure at the following fees, was held not to be a notice of termination and did not establish an anticipatory breach, excusing Thistledown from its obligation of the contract. A repudiating party can retract the repudiation unless the aggrieved has what? Materially changed its position. Tendeka Incorporated, a manufacturer of a tool utilized in fracking horizontal oil wells, sent a June letter to its customers, Nine Engine Service LLC, changing the price of its packers from $2,800 to $3,000 per unit, and canceled its consignment terms and required immediate payment rather than invoicing when the packers were used. 1 month later, Tendeka sent a subsequent letter reminding Nine Energy of its minimum purchase obligation under its existing October agreement, noting that it has purchased just 1,923 packers out of 3,000 guaranteed volume for the year. On its face, the June letter changed the three main components of its October agreement: price, consignment, and payment terms, which was sufficient evidence for Nine Energy to meet its burden to show the affirmative defense of repudiation. And since Nine Energy materially changed its position in reliance on the repudiation, Tendeka could not retract its repudiation. What is anticipatory repudiation by conduct? What's that? The anticipatory repudiation may be expressed by conduct that makes it impossible for the repudiating party to perform subsequently. For example, while the town of Mammoth Lakes, California, was claiming a willingness to move forward with a hotel condominium project under its contract with the developer, in actuality, the evidence established that town officials refused to move forward and actively sought to undermine the developer's rights under the development contract. The court affirmed its judgment of $30 million in damages and attorney fees. Waiver of breach. That's what happened with what? Ms. Rivera? What cast? The Friends cast, right? Who breached the second time, Ms. Smith? Mr. Joyce? Mr. Andrew? The second time. Who blinked the second time?
Who blinked?
Let me ask that question. Yeah, who blinked the second time?
The cast.
The Friends cast. They blinked the second time, right? Who blinked the first time?
NBC.
NBC. And did the Friends cast breach their contract on August 12, 1996?
Yes.
Yeah, and what kind of breach was it? What are we talking about right now? Anticipatory repudiation, right? So, anticipatory repudiation by conduct. Anticipatory repudiation may be expressed by conduct that makes it impossible for the repudiating party to perform subsequently. Oh, I read that already. Okay. Waiver, and right, waiving, NBC waived. Why? I forgot to ask the question. Mr. Thomas, why they waive? When I asked it in my other class, someone actually gave that answer. When they gave the answer, I just got finished asking you. You want to pick up your grade summary sheet, okay? On Monday, we'll go over that. Now, I'll show you your grades on Excel and, give you an idea where you stand, okay? All my students, I like to do that before you take the final test. What was my question I was saying? Oh yeah, why they waive it? My good people, why? Why did NBC waive?
Because they wanted to keep the same Friends cast.
What they had? What kind of deal did they make?
Everybody not get this?
What kind of deal? How much money?
A lot.
For syndication? How much?
40 million.
Thank you. 40 million. Right. 40 million. Very good. Very good. You got it going on. That's what I'm talking about. Let's see. Where's Rev? The breach of contract may have no importance because the other party to the contract waives the breach. So the breach of contract may have no importance because the other party to the contract waives the breach. Okay. Very good. All right. I have up here in my margins the Friends cast. Cure, or on page 360, 19-2A, cure a breach of waiver. By the way, I will be going over, see Kurt Flood, I have him up here on the screen later on. I'm gonna get to that, Kurt Flood. That'll be on your test, okay? Reserve clause, I mentioned that earlier. I gave out the answers earlier also, Muhammad Ali. I gave out the answers already, but I'll do it a little later on. The fact that one party has broken a contract does not necessarily mean that there will be a lawsuit or forfeiture of the contract. For practical business reasons, one party may be willing to ignore or waive the breach. When it is established that there has been a waiver of a breach, the party waiving the breach cannot take any action on the theory that the contract was broken. The waiver, in effect, erases the past breach. The contract continues as though the breach had not existed. The waiver may be expressed or it may be implied from the continuing recognition of the existence of the contract by agreed party. When the conduct of the party shows intent to give up a right, it waives that right. Okay, so I have over here my margins, friends. Why did NBC waive the breach? Okay, we already went over that. We have a contract to have in by November 30th, 50,000. I think I gave the example of this class last time, right? What Black Panther doll? What's the young lady? Shuri, right? Shuri dolls, right? And they don't get them into us by 12 noon. I gave this example last class, right?
Yeah.
Good. So you all should know the answers, right? What can we do?
Waive it,
Yeah, a waiver, right? Why would we do that?
because the kids want their presents.
And we have been dealing with this person, right? And, maybe the weather was bad, whatever, even though there was not a weather clause, or there should be a weather clause in contracts. We talked about that already, too, last chapter, right? That's 18, all's in there, right? We're going to waive and give them an opportunity to deliver the items tomorrow, okay? So that's what we're talking about here. The existence and scope of waiver, page 360, 19-2D. It is a question of fact whether there has been a waiver? It's a question of fact whether there has been a waiver? What are you talking about? A question of fact. Huh? What do you mean by that? Whether there's been a waiver or not? Huh? It is a question of fact whether there has been a waiver. Is this a waiver? A party may express or declare that the breach of contract is waived. A waiver or a breach is more often the result of an express forgiving of a breach. So we're forgiving the person, right? Thus, a party allowing the other party to continue performance without objecting that the performance is not satisfactory waives the right to raise objection when sued for payment by the performing party. For example, a contract promised to sell back a parcel of commercial property to Jackson required Jackson to make a $500 payment to Macy's attorney on the first of the month for 5 months, December through April. It was clearly understood that the payments would be, quote, on time without fail. Jackson made the December payment on time. The New Year's Day, a holiday, fell on a Friday, and Jackson made a second payment on January 4th. He made $500 payments on February 1st, March 1st, and March 31st, respectively, and the payments were accepted and a receipt issued on each occasion. However, Mays refused to convey title back to Jackson because the January 4th payment untimely and the parties' agreement had been breached. The court held what? The doctrine of waiver applied due to Mays' acceptance of the late payment and the 3 subsequent payments without objection, and the court declared that Jackson was entitled to what? Possession of the land. What is the scope of a waiver? The waiver of breach of contract extends only to the matter what? Waived. It does not show any intent to ignore other provisions of the contract. What is an anti-modification clause? Modern contracts commonly specify the terms of contract shall not be deemed modified by waiver as to any breaches. This means the original contract remains as agreed to. Either party may therefore return to and insist on what? Compliance with the original contract. In the example involving Jackson Macy's contract, the trial court reviewed the contract to see whether the court was restricted by the contract from applying the waiver. It concluded, quote, in this case, the parties' contract did not contain any term that could prevent the application of the doctrine of waiver to the acceptance of late payments. End of quote. Go with me now to page 361. I've got the example of the Batman doll, right? The reservation right. We have a Batman doll. Batman doll is supposed to say, to the Batmobile, Robin. And the Robin doll is supposed to say what? What now, Batman? Right? But instead, the Batman doll says what? Batman doll says what? What now, Batman? What's Robin doll say? To Batman, Robin, right? There's a problem, right? Now we have Christmas, Hanukkah, Ramadan, Three Kings Day, Kwanzaa, Solar. Did I miss anything?
Boxing Day.
Huh?
Boxing Day.
Boxing Day? Is that in December too? Okay.
January.
Okay. Well, okay. Boxing. You have it coming, right? And we need these dolls, right? Because the kids want that, right? And they're defective. What do we do? What do we do with these defective dolls? We can't. We're going to lose money for Christmas time. Hanukkah, Ramadan, Three Kings Day, Solar, Boxing Day. So here's the answer. Reservation of rights. What is a reservation of rights? It may be that a party is willing to accept a defective performance, or accept the defective Batman doll, right, Robin doll, but does not wish to surrender any claim for damages for the breach. In other words, we're going to do what? Sue for what? Show me the who? The money. For example, Midwestern Utilities Incorporated accepted 20 carloads of Powder River Basin coal, sometimes called Western Coal, from its supplier, Maney Enterprise, because its power plants were in short supply of coal. Midwest Requirements contract with Macy called for Appalachian Coal, a low sulfur, highly efficient fuel, which is sold at premium price per ton. Midwest accepting the tendered performance with a reservation of rights. What? Gave notice to Maney that it's reserved all rights to pursue damage for the tender of what? Non-conforming shipment. Non-conforming shipment. All right? Remedies for breach of contract. We've seen this before, right? One or more remedies may be available, we're at chapter 2, right? To innocent party in the case of a breach of a contract. There's also a possibility that arbitration and streamlined out-of-court alternative dispute resolution procedure. That's chapter 2, right? Nice review. This chapter does a lot of review, doesn't it? Is available or required for determining the right of the parties. What are some remedies upon anticipatory repudiation? When an anticipatory repudiation of a contract occurs, the aggrieved person has several options. The individual may, 1, do nothing beyond stating that performance at the proper time will be required. 2, regard the contract as having been definitively broken and bring a lawsuit against the repudiating party without waiting to see whether there will be proper performance when the performance date arrives. Or 3, regard the repudiation as an offer to what? Cancel the contract. This offer can be accepted or rejected. Is accepted, there is a discharge of the original contract by the subsequent cancellation agreement of the parties. Okay. 19-3B, page 361. This is from chapter 11, right? We've seen this before, right? Courts provide a what? Quasi-contractual or restitution remedy in which a contract is unenforceable because it lacked definite and certain terms or was not in compliance with the statute of frauds, yet one of the parties performed service for the other. Oh, remedies in general and measure of damages? The measure of damages in these and other quasi-contract cases is the what? You've seen this before. Reasonable value of service performed, not an amount derived from the defective contract. In cases when a person retains money or when a contemplated contract is not properly formed and no work is performed, the party retaining the benefit is obligated to make restitution to the person conferring the benefit. For example, Kramer Associates Incorporated, KAI, a Washington, D.C. consulting firm, accepted $75,000 from a Ghanaian-based corporation, ICANN Ltd., to secure finance for a Ghanaian development project. No contract was ever executed, and KAI did virtually nothing to secure financing for the project. Restitution of the $75,000 was what? Was required. Oh! Next paragraph has something from what? Chapter number 1. Where there is a breach of contract, the regular remedy is an award of what? Show me the what? Money! Monetary damages. In unusual circumstances, when monetary damages are inadequate, the injured party may obtain what? Specific what?
Performance.
Yeah, specific performance, whereby the court will order that the contract terms be carried out. Remember, we bought a house in Hawaii. We were all supposed to move into it, and they didn't want to give us the what? The keys. After we did the mortgage, paid everything, signed all the papers. Do we want our money back? We want the what? The keys to the house, right? That's specific performance. The measure of monetary damages when there has been a breach of contract is the sum of money that will place the injured party in the same position that would have been attained if the contract had been what? Performed. That is, the injured party will be given what? The benefit of the bargain by the court. As seen in the Tips versus Heartland developers case, the non-breaching party, Heartland, was awarded the contract price less the cost of completion of the project, which had the effect of giving the builder the benefit of the bargain. Right? What are the common classifications for monetary damages? What are monetary damages? We're on page 362. Don't forget the diagrams you have to know, right? You have to know those diagrams on page what? 303 and what? Page 342, right? Go back and take a make sure we have the right ones, my wonderful people. Just take a moment, take a look. Make sure I always ask those on the final exam. So it was statute of frauds, right? And then you have your causes of contract discharge, right? Very important. Monetary damages. Ooh, money damages. Monetary damages are commonly classified as compensatory damages. You have to know this stuff. Gonna be on your test. Nominal damages, punitive damages, also known as what? Exemplary damages, also known as what? Punishment damages, right? Right? Compensatory damages compensate the injured party for what? Damages incurred as a result of the breach of the what? The contract. Compensatory damages have two branches. What are they? Direct and consequential. What's another name for consequential? Special. Excellent. Injured parties that do not sustain an actual loss because of a breach of contract are entitled to a judgment of a small sum of money, such as $1. These damages are called what? Nominal damages. Damages in excess of actual loss imposed for the purpose of punishing or making an example of the defendant are known as punitive damages or exemplary damages. In contract actions, punitive damages are not ordinarily awarded. All right, turn with me now to page 363. Under compensatory damages, what do we have? We have direct damages and we have consequential damages. What are direct damages? What's another name for direct damages? General damages, very good. Direct damages, sometimes called general damages, are those, and I have a lot of this underlined in the book, are those that naturally flow from the given type of breach of contract involved and include incidental damages, which are extra expenditures made by the injured party to rectify the breach or mitigate the damages. Ooh, what happened to Spencer Adams? What happened to him? We're going to find out in a moment, right? Consequential damages might be on your test too, huh? High probability. Sometimes called special damages are those that do not necessarily flow from the type of breach of contract involved, but happen to do so in a particular case as a result of the injured party's particular circumstance. And that test is test number 4, what, part 1? Or it might be on test number 4, part 2, right? We'll see. When do you recover consequential damages? 363. Consequential damages may be recovered only if what? Reasonably foreseeable to the defendant that what? The kind of loss in question could be sustained by the non-breaching party if the contract were broken. Now, let's check out what happened with Spencer Adams. In early, let me make sure I have this on tape. All right. You have it there? Very good. In early August, Spencer Adams ordered a 4-wheel drive GMC truck with a rear-end hydraulic lift for use on his Aroostook County, Maine potato farm. The contract price was $73,500. He told Brad Jones, the owner of the dealership, that he had to have the truck by Labor Day. Why? So he could use it to bring in the crop from the fields before the first frost. He told him, I need this before the first frost, right? And what did Brad do? And Brad nodded that he understood. You see where this is going, right? The truck did not arrive by Labor Day as promised in the written contract. After a 2-week period of gradual escalating recriminations, that means they're fighting, right? With the dealership, Adams obtained the same model GMC truck at a dealership 40 minutes away in Holton, but at a cost of how much? $75,000 what? $500. He was also able to what? Rent a similar truck from the Holton dealer for $250 for the day while the new truck was being prepared. Farmhands had used other means of harvesting, but because of the lack of the truck, what happened? Their work was set back by 5 days. As a result of the delays, 30% of the crop was still in the fields when the first crop came, causing damages expertly estimated at $320,000. Okay, what's going to happen? The direct damages for the breach of contract in this case would be the difference between the contract price for the truck of $73,500 and the market price of $75,500 or $2,000. These direct damages naturally flow from the breach of contract for the purchase of a truck. What else do we want? Incidental damages. Also, the incidental damages of $250 for the truck rental are recoverable direct damages. The $320,000 loss of the potato crop was a consequence of what? Not having the truck. And this sum is arguably recoverable by Spencer Adams as what? Consequential or what? Special damages. Yes, yes. Turn the page to page 364. Adams notified, how do we get this as consequential damages? Special damages, how? Because Adams notified Brad Jones the reason he needed to have the truck by Labor Day, right? And didn't he nod? Like, yeah, I understand, right? And it should have been reasonably foreseeable to Jones that loss of a portion of the crop could occur if the truck contract was breached. Now, conjunctive adverb. However, because of Spencer Adams' obligation to mitigate. What does it mean to mitigate? What's mitigation of damages? As discussed next, it is unlikely that Adams will cover the full consequential damages. Truck rental availability or the lack of availability within the rural area, alternative tractor usage, and the actual harvesting methods used by Adams all relate to the mitigation issue to be resolved by whom?
The jury.
The jury. Very good. Page 364, mitigation of damages. The injured party is under the duty to mitigate damages if reasonably possible. What's that mean? The injured party is under the duty to mitigate damages if reasonably possible. They must do what? You must prevent what? In other words, damages must not be permitted to increase if an increase can be prevented by reasonable efforts, right? You have to try to save as much money as possible. This means that the injured party must generally stop any performance under the contract to avoid running up a larger bill. The duty to mitigate may require an injured party to buy or rent elsewhere the goods that the wrongdoer was obligated to deliver under the contract. So we can't get our Batman dolls, right, and Robin dolls from this supplier. We have to go to somebody else, right? Maybe pay more money. In the case of breach of an employment contract by the employer, the employee is required to seek other similar employment. The wages earned from other employment must be deducted from the damages claimed. A discharged employee, however, is not required to take employment of less than comparable work. Okay. Effect of failure to mitigate. What happens when that occurs? The effect of the requirement of mitigating damages is limited. The effect of the requirement of mitigating damages is to limit recovery by the non-breaching party to the damages that would have been sustained had this party mitigated damages where it was possible to do so. Okay. So what's that mean? You get to limit recovery of the non-breaching party, right? Because they should have done what? Mitigated, right? Found some type of other way to get the items. So the effective requirement of mitigating damages to is to limit recovery by the non-breach party to the damages that would have been sustained had this party mitigated the damages where it was possible to do so. When it's possible to do so. Okay, page 365. What is rescission? What is that? What's rescission? 19-3D. When one party commits a material breach of the contract, the other party may what? Rescind the contract. We've seen that before, right? If the party in default objects, the aggrieved party may bring an action for rescission. A breach is material when it is so substantial that it defeats the object of the parties in making the contract. Rescind, right? When one party commits a material breach, it's got to be material though, right? Of the contract. The other party may rescind, get out of it, the contract. If the party in default objects, the aggrieved party may bring an action for rescission. A breach is material when it is so substantial that it defeats the reason why the parties had the contract, defeats the object of the parties in making the contract. Bottom of page 365. How do you recover? An injured party who rescinds a contract after having performed services may recover the reasonable value of the performance rendered under restitutionary or what? Quasi-contractual damage. We've seen that before, right? Chapter 11. Money paid, again, this is a nice review. Money paid by the injured party may also be recovered. She signed a purchase agreement to buy a building owned by Berenstein Associates for $2 million. Thereafter, the parties learned environmental contamination of the property. Faced with uncertainty about the scope of the problem, the cost of the cleanup, the deal fell through and litigation ensued. Trial court rescinded the agreement based on mutual mistake of the fact because neither party knew the full extent of the environmental hazard at the property. And that, again, we talked about mutual mistake before also. Damages available to the parties upon mistake are more limited than those available in cases in which rescission is based on fault. Were awarded $61,423.82 expenses and an order returning their $115,000 deposit. Okay, very good. Turn the page, please. Page 366. I have on my my book here, the margins. I have, what is the purpose of rescission? Where have we seen this? What is the equitable remedy of performance? A lot of other things too. What is the purpose of rescission? Or what do we both? Why do we have it? What's the purpose of rescission? The purpose of rescission is to restore the injured parties to the position occupied before the contract was made. However, the party seeking restitutionary damage must also return what this party has received from the party in default. Pedro Marina purchased real estate from Jason Alexander. Alexander had assured him that the property did not have a flooding problem. In fact, the property regularly flooded after ordinary rainstorms. Marina was entitled to return of the purchase price and payment for the reasonable value of what? The improvements he made to the property. Alexander was entitled to set off what? Alexander was entitled to a set-off for the reasonable rental value of the property during the time Marina was in possession of this property. 19-3E. Again, review. Action for specific performance. Under special circumstances, an injured party may obtain the equitable remedy of specific performance which compels the other party to carry out the terms of a contract. Specific performance is ordinarily granted only if the subject matter of the contract is what? Quote, unique, thereby making an award of monetary damages an inadequate remedy. Contracts for the purchase of land will be specifically enforced. Specific performance of a contract to sell property, personal property can be attained only if the article was of an unusual age, beauty, unique history, or other distinction. For example, Maurice owned a rare Revolutionary War musket that he agreed to sell to Herb. Maurice then changed his mind because of the uniqueness of the musket. Herb can sue and win, requesting the remedy of specific performance of the contract because of the unique nature of the goods. We've seen this before, right? Again, we want the keys to the house in Hawaii, right? Okay. When the damage is sustained by the plaintiff can be measured in monetary terms, specific performance will be refused. That means money damages, right? Consequently, a contract to sell a television station will not be specifically enforced when the buyer had made a contract to resell the station to a third person. Damages caused by the breach of the first contract would be the loss sustained by being unable to make the resale, and such damage would be adequate compensation to the original buyer. Ordinarily, contracts for the purchase of personal service are not specifically ordered. This is because of the difficulty of supervision by the court and the restriction of the United States Constitution's 13th Amendment prohibiting involuntary servitude except as criminal punishment. What's an injunction? Junction. What's your function? What's that? 19-3F. When a breach of contract consists of doing an act prohibited by the contract, a possible remedy is an injunction against the doing the act. For example, when the obligation in an employee's contract is to refrain from competing after resigning from the company, and the obligation is broken by competing, a court may order the former employee to stop competing. Similarly, when a vocalist breaks a contract to record exclusively for a particular label, she may be enjoined from recording for any other company. This may have the indirect effect of compelling the vocalist to record for the plaintiff. What's reformation? We've seen that too. Review. Reformation of contract by court. At times, a written contract does not correctly state the agreement already made by the parties. When this occurs, either party may seek to have the court what? Reform or what? Correct the writing, right? To state the agreement actually made. They're not going to do a new contract. They're going to bring the parties to the meeting of minds where they were in the original contract, right? Right, remember that before. We talked about that. Top of page 367. A party seeking reformation of a contract must clearly prove both the grounds for reformation and what the agreement actually was. This burden is particularly great when the contract to be reformed is written. This is so because the general rule is that parties are what? What happened with Jacqueline? 20 years old. She was competent, right, when she signed the contract? A party seeking reformation of contract must clearly prove that both the grounds for the reformation and what the agreement actually was. This burden is particularly great when the contract to be reformed is written. This is so because the general rule is that parties are presumed to have read their written contracts and to have intended to be bound by them when they signed the contracts, right? When a unilateral mistake is made and it is of such consequence that enforcing the contract according to its terms would be unconscionable, a court may reform the contract to correct the mistake. Bottom of page 367, 19-4, contract provisions affecting remedies and damages. The contract of the parties may contain provisions that affect the remedies available or the recovery of damages. 19-4A, limitation of remedies. The contract of the parties may limit the remedies of the agreed parties. Remember seeing this in law school? I think on the bar exam too. For example, the contract may give one party the right to repair or replace a defective item sold or to refund the contract price. The contract may require both parties to submit any dispute to arbitration or another stream out of court dispute resolution procedure. Turn the page, please, to 368. What are liquidated damages? What are they? What in the world is a liquidated damage? 19-4B. The parties may stipulate in their contract that a certain amount should be paid in case of a breach. This amount is known as liquidated damages and may be variously measured by the parties. When delay is possible, liquidated damages may be a fixed sum, such as $1,000 for each day of delay. So when delay is possible, liquidated damage may be a fixed sum, such as $1,000 for each day of delay. When there's a total default, damage may be a percentage of the contract price or the amount of the down payment. Can a liquidated damage be a penalty? What's the answer? Answer is no, it cannot be, okay? What's the validity of a liquidated damage clause? To be valid, a liquidated damage clause must satisfy two requirements. Number one, situation must be one in which it is difficult or impossible to what? To determine the actual damages. And two, the amount specified must not be excessive when compared with the probable damages that would be sustained. The validity of a liquidated damage clause is determined on the basis of facts existing when the clause was agreed to at the time entering an agreement. Look at the existing facts at that time. Now, what's the effect? When a liquidated damage clause is held valid, the injured party cannot collect more than the amount specified by the clause, because that's what was agreed upon, right? In case of damage, okay? The defaulting party is bound to pay such damages once the fact is established that there has been a default. The injured party is not required to make any proof as to damages sustained, and the defendant is not permitted to show that the damages were not as great as the liquidated sum. Why? Because this is what was agreed upon earlier, right? What happened? What happens if the court deems liquidated damage clause invalid? What happens if the court deems the liquidated damage clause invalid? If the liquidated damage clause calls for the payment of a sum that is clearly unreasonable. If the liquidated damage clause calls for the payment of a sum that is clearly unreasonably large and unrelated to the possible actual damages that might be sustained, the clause be held to be what? Void as what? As a penalty. You can't have a penalty, right? For example, a settlement agreement between 27 plaintiffs seeking recovery for injuries sustained, injuries resulting from the faulty breast implants, and the implants manufacturer Dow Corning Corporation called for $7 $20,000 payments to each plaintiff. The agreement also called for $100 per day payment to each plaintiff for any time when the payments were late as liquidated damages. The court held that the $100 per day figure was not a reasonable estimate of anticipated damages, rather it was an unenforceable penalty provision. Margins, can you recover what you can recover what you can prove if the liquidated damage clause is deemed invalid? Okay. When a liquidated damage clause is held invalid, the effect is merely to erase the clause from the contract. The injured party may proceed to recover damages for the breach of the contract. Instead of recovering the liquidated damages amount, the injured party will recover whatever actual damages can be what? Proved. For example, Richard Colbert and his wife Valerie breached a 5-year restricted covenant in a settlement agreement with the Medical Devices Corporation that Goldblatt had co-founded, CP Motion Incorporated, a liquidated damages provision in the settlement agreement that obligated Goldblatt and his wife to pay $250,000 per breach of the restricted covenant was unenforceable as a penalty clause. The appeals court set aside a $4,969,039 judgment against the Goldblatts, determining that the parties could have agreed to arrive at actual damages by calculating a percentage of the lost profits of specific lost clients or reclaiming any profits gained by the breaching party. Because the liquidated damages clause was a penalty provision, CP Morton Incorporated may only recover what? Actual damages filed and proven at trial. Okay? Very good. Let's go now to page 369. What's pro bono? What's attorney fees? Attorney fees are a very significant factor in contract litigation. In MedStar, the corporation sued against Dr. David Smith, the jury awarded $418,069 in damages under its promissory estoppel claim. Oh, promissory estoppel? Remember that? Talk about that too. And in addition, and again review, in addition thereto, the trial court judge allowed MedStar to recover $408,412 for its attorney fees. A state statute allows recovery of attorney's fees for the prevailing party in a breach of partnership claim. On appeal, the recovery of $408,412 in attorney fees was reversed, since the jury awarded zero damages on MedStar's breach of partnership claim. The net result after payment of attorney fees and not counting attorney fees for the appeal was $9,657 for MedStar after 4 years of successful litigation. The so-called American rule states that each party is responsible for its own attorney's fees in the absence of express contractual or statutory provision to the contrary. Even in the event of a valid contractual provision for attorney fees, a trial court has discretion to exercise its equitable control to allow only such sum as is reasonable, or the court may properly disallow attorney fees altogether on the basis that such recovery would be inequitable. For example, although Evergreen Tree Care Services was awarded some monetary damages in its breach of contract suit against JHL Incorporated, it was unsuccessful in its claim for attorney fees under revision for attorney fees in the contract because the trial court exercised its equitable discretion, finding that both parties to the litigation came to court with unclean hands, and the Evergreen failed to sufficiently itemize and exclude fees to discovery abuses. Page 369, 19-4D. Limitation of liability clauses. What's this? A contract may contain a provision stating that one of the parties shall not be liable for damages in case of a breach. Such a provision is called exculpatory clause. Or when a monetary limit to damages for breach of contract is set forth in contract, it is referred to as a limitation liability clause. Okay? Content and construction. If an exculpatory clause or limitation liability clause limits liability for damages caused only by negligent conduct, liability is neither excluded nor limited if the conduct alleged is found to be what? Grossly negligent, willful, wanton. For example, Security Guards Incorporated, SGI, provided service to Dana Corporation, a truck frame manufacturer, under a contract that contained a limitation liability clause capping losses at $50,000 per occurrence for damages, quote, caused solely by the negligence, end of quote, of SGI or its employees. When a critical alarm was activated fire in the plant shop at 5:39 p.m., the SGI guard on duty did not follow proper appropriate procedure, which delayed notification to the fire department for 15 minutes. Royal Indemnity Company, Dana's insurer, paid Dana $16,535,882 for the fire loss and sued SGI for $7 million, contending that SGI guards' actions were grossly negligent and caused the plant to suffer increased damage. The court held that if SGI were to be found grossly negligent, the liability would not be limited to $50,000, and a jury could find damages for exceeding that amount. Are exculpatory clauses favored by courts? While contracts that exculpate persons from liability are not favored by courts because they encourage lack of care and are thereafter strictly construed against the person or entity, turn the page, seeking escape liability, nevertheless, when the language of the contract and the intent of the parties are clearly exculpatory, the contract will be upheld. This principle arises out of a broad policy of the law, which accords to contracting parties freedom to bind themselves as they see fit. For example, exculpatory clause in a rental contract that David Hyatt signed with Mini Storage on the Green, which was clearly exculpatory, relieved Mini Storage of liability for injuries Hyatt suffered when the unit door he was pulling down with some extra force came off its tracks and injured him. Releases. Release forms signed by participants in athletic and sporting events declaring that the sponsor, proprietor, or operator of the event shall not be liable for injuries sustained by participants because of its negligence are generally binding. Wow. Summary. Someone read the summary for me, please, on page 371. Summary. Nice and loud.
When a party fails to perform a contract or performs improperly, the other contracting party may sue for damages caused by the breach. What may be recovered by the aggrieved person is stated in terms of being direct or consequential damages. Direct damages are those that are ordinarily will result from the breach. Direct damages may be recovered on proof of causation and amount. Consequential damages can be recovered only if, in addition to proving causation and amount, it is shown that they were reasonably within the contemplation of the contracting parties as a possible breach or probable result of a breach of the contract. The right to recover consequential damages is lost if the aggrieved party only could have reasonably have taken steps to avoid such damages. In other words, the aggrieved person has a duty to mitigate or reduce damages by reasonable means. In any case, the damages recoverable for a breach of contract may be limited to a specific amount by a liquidated damages clause. In a limited number of situations, an aggrieved party may bring an action for specific performance to compel the other contracting party to perform the acts called for by the contract. Specific performance by the seller is always obtainable for the breach of a contract to sell land or real estate on the theory that such property has a unique value. With respect to other contracts, specific performance will not be ordered unless it is shown that there was some unique element present so that the aggrieved person would suffer damage that cannot be compensated for the payment of money damages.
Thank you. The aggrieved person also has the option of rescinding the contract if one, the breach has been what? Made during a material term, right? The breach has been made concerning a what? A material term. And two, the aggrieved party returns everything to the way it was before the contract was made. Although there's been a breach of the contract, the effect of this breach is nullified if the aggrieved party by word or conduct waives the right to object to the breach. Conversely, an aggrieved party may accept a defective performance without thereby waiving a claim for breach if the party makes a what? The Batman dolls. Reservation of rights. Reservation of rights can be made by stating that the defective performance is accepted without prejudice, under protest, or with reservation of rights. All right. Now let me go now to our board here.